GOA has teamed up with FRAC, the Firearms Regulatory Accountability Coalition, to send a letter to the Department of Justice about a deeply concerning criminal charge for possession of a pistol-braced firearm. This prosecution could have very serious consequences beyond just this case, as millions of gun owners, including countless GOA members, are firearms owners with pistol braces, which is why we're following this case closely and have taken action on our end with this letter. Hi, I'm Phil, and you're watching Law and Ammo. But before we get into the video, I want to take a second to tell you about GOA's annual convention, Goals. The Gun Owners Advocacy and Leadership Summit is set to be held August 9th through 10th this year in Knoxville, Tennessee. Come out and visit with some of your favorite manufacturers, participate in activism training, and hear from the top voices in the Second Amendment community. And the best part is that it's free for GOA members. So sign up today using the link in the description. Now back to the video. So, GOA and our friends at FRAC have just sent a letter to the Department of Justice, specifically to the prosecutors in the U.S. Attorney's Office in the District of Columbia, asking the DOJ to dismiss one particular charge in the case U.S. v. Toronto. But before we get into the details of the case, let me point out that GOA and FRAC's interest in this case is the NFA charge for possessing a pistol-braced handgun. Nothing else. We state this clearly in our letter when we say we express no opinion on any of the other unrelated charges levied against Mr. Toronto. This is because, similar to the case in U.S. v. Rahimi, while we see this pistol brace charge as an example of bad policy that we need to push back on, some of the other allegations against Mr. Toronto are pretty serious. Toronto's case stems from an incident on June 28, 2023, where Toronto was stopped by the Secret Service and FBI in Washington, D.C., and charged with the possession of a firearm and magazines. But in the hours leading up to his arrest, Toronto had engaged in what charging documents describe as erratic behavior, was live streaming himself, and according to charging documents, suggested that he had outfitted his vehicle with a detonator. He then drove his car into Washington, D.C., specifically into the Kalorama neighborhood and into an area monitored by the Secret Service because of its proximity to President Barack Obama. When the Secret Service approached him, he fled into the woods. The officers gave chase. And eventually, when the Secret Service arrested him and conducted a search of his vehicle, they found a CZ Scorpion pistol with a brace and a lot of magazines. Toronto was charged with numerous offenses, but interestingly, according to his indictment, Toronto's pistol is charged as both a handgun in violation of Washington, D.C.'s licensing provisions, and also a short-barreled rifle in violation of the National Firearms Act. This is starting to sound like Schrodinger's CZ Scorpion, and for all you baristas with a philosophy degree, you might get that reference. Quantum mechanics aside, how can a firearm be both a pistol and a rifle at the same time? The answer is, of course, that it isn't. And DOJ's internally conflicting position shows that the government is using the NFA charge for a sinister reason and may be a sign of a larger problem. And we'll get into that in a second. You might be asking right now, however, I thought that ATF's pistol brace rule was dead, vacated. Doesn't that mean the ATF can't enforce it? Well, that's correct. And you'd think that the ATF would follow the numerous judges' orders that have enjoined enforcement of the rule. But ATF and the DOJ attorneys on the case insist that they're not enforcing the rule at all. They're simply enforcing the NFA, the statute itself. In a brief filed by the DOJ lawyers opposing a motion to dismiss by Toronto, the U.S. attorneys had this to say: ATF is not barred from continuing to enforce the underlying statute, as it always has, by making case-by-case determinations about whether particular braced firearms constitute rifles under the statute. And of course, because the rule reflects ATF's best understanding of the statute, those determinations will naturally tend to look substantially like the determinations that would follow from applying the clear framework outlined in the rule. Translation: even though the ATF is currently barred from enforcing the pistol brace rule, They say there's nothing stopping them from enforcing the statute, using, of course, the very same legal theories on which the rule is based. If this sort of logic that appeals only to bureaucrats makes your eyes burn, you're not alone. But we've heard all of this before. Just a few weeks ago, we saw a similar occurrence where a GOA member reached out to the ATF about a different CZ Scorpion mini pistol, asking ATF if installing a pistol brace would require registration under the NFA. ATF's response? Well, federal law requires a pistol with an attached stabilizing brace or stock to be registered as a short-barreled rifle. ATF then says, a firearm designed and intended to be fired from the shoulder that meets the statutory definition of a short-barreled rifle contained in the NFA, regardless of what is used as a stock, must be made and transferred in accordance with the statutory requirements of the NFA. After our member got that email, GOA sent a letter to the ATF, informing them of their mistake and demanding that ATF retract its claim that any pistol equipped with a stabilizing brace automatically becomes a short-barreled rifle, along with assurances that they weren't planning to start charging gun owners with NFA violations for owning a braced pistol. In response, ATF sort of walked back its comments, but begrudgingly, saying that its previous statement was overbroad and that they agreed with us that addition of a pistol brace doesn't automatically turn a pistol into a rifle. But there's also another important part of the ATF's response to our member. When ATF claimed that the district court order enjoining the rule does not prohibit ATF's enforcement of the statute, the National Firearms Act. That sounds familiar, right? That's exactly what the DOJ is claiming here in the Taranto case. And so it appears that the bureaucrats at ATF, along with some holdover prosecutors in the DOJ, just aren't willing to give up their anti-gun agenda. And so this is why we've teamed up with FRAC to send this letter, this time to the U.S. Attorney's Office in Washington, D.C., asking that office to investigate this overreach by the federal government. In our letter, GOA's Eric Pratt and FRAC's Travis White had this to say. The government's superseding indictment simultaneously alleges that Mr. Taranto's Scorpion CZ is both a pistol in violation of the District of Columbia's licensing provisions and also a short-barreled rifle in violation of the NFA. But these legal definitions are mutually exclusive and show that the federal charges cannot stand. Stabilizing braces, like the one that Mr. Taranto is alleged to possess, are not shoulder stocks, nor do they transform otherwise lawful pistols into short-barreled rifles. However, under the former Biden administration, ATF wrongly attempted to turn millions of American gun owners who possess firearms with stabilizing braces into felons through regulation. But ATF's rule was short-lived. GOA, FRAC, and other groups filed an array of suits to challenge the rule, and several courts held the rule unlawful on multiple grounds. These rulings ultimately culminated in the rule's wholesale vacatur by a federal district court. And so right now, the ATF's rule criminalizing braced pistols is not in effect, and yet Mr. Taranto remains charged with possession of a braced pistol. ATF's handling of this issue, including its unlawful final rule, has been a textbook example of regulatory overreach and legal inconsistency. The Trump administration has echoed our concerns, and to that end, President Trump recently signed an executive order entitled Protecting Second Amendment Rights, which mandates a thorough review of all firearm-related cases for consistency with the Second Amendment and the administration's enforcement objectives. We presume Mr. Taranto's case likewise will be part of the department's review in compliance with the president's order, and we trust you will see fit to dismiss this erroneous NFA charge. Dismissal of the federal NFA charge against Mr. Taranto would serve to protect the law-abiding and inspire confidence in a uniform application of federal law. We're hopeful that, thanks to President Trump's executive order on protecting Second Amendment rights, this charge will be dismissed, protecting gun owners from more ATF overreach. Again, this case and GOA's interest has nothing to do with Mr. Taranto, but instead with the millions of gun owners who possess firearms equipped with pistol stabilizing braces. If the DOJ pushes forward with this criminal charge against Taranto, then all of us are at risk. We'll keep you updated as this situation continues. I'm Phil with Law and Ammo. Thanks for watching.